I want to tell you about the day I found out my sister had taken everything. Not some of it, everything. The savings account my father had built over 40 years of early mornings and late nights, and every small sacrifice that working people make when they are trying to leave something behind for the people they love. The investment portfolio my mother had managed with the quiet precision of a woman who understood that money, tended carefully, grows into something meaningful. The house, the jewelry, the documents my parents had spent an afternoon with their attorney preparing, carefully, specifically, with both their daughters in mind. All of it, gone, redirected, into accounts I didn't know existed, controlled by a sister I thought I knew. Sarah and I had been close once. Not always easy. We were different in the ways that sisters often are. She was louder, more social, the daughter who remembered every birthday and organized every gathering, and made our parents laugh at Sunday dinners with the specific gift of a person who understands that joy requires maintenance. I was quieter, more internal, the daughter who showed up consistently without fanfare and assumed that love, expressed through reliability, was enough. We had not always understood each other, but we had always been family. Or so I believed. Our parents died within 14 months of each other. First our father, then our mother, who had, I believed, simply decided that a world without him was one she didn't want to navigate for long. The grief had been enormous. The estate process, I had assumed, would be straightforward. My parents had been organized people, careful people, the kind of people who updated their documents and kept their affairs in order because they understood that the greatest gift you can leave your children is clarity. Sarah offered to handle it. She was the older one, the organized one, the one who had always managed the family logistics with cheerful efficiency. "I'll take care of everything," she said. "You're grieving. Let me handle this." I was grieving, so I let her. That was the mistake that cost me everything. 11 months after our mother passed, I received a letter from the estate attorney. Not the attorney my parents had used for 32 years, a different one, informing me that the estate had been settled and that my share, per the amended documentation, was significantly less than what my parents had intended. Amended documentation. I read those 2 words 3 times. Then I called my parents' original attorney. Patricia Huang had handled my parents' affairs for 32 years. She picked up on the second ring. And what she told me, carefully, precisely, with the controlled anger of a professional who has seen this before and never stops being appalled by it, changed everything. Patricia told me about the documents. The original will, prepared 7 years ago, updated twice, witnessed correctly, had divided the estate equally between Sarah and me, 50-50. Clear, unambiguous, the way my parents did everything. What Sarah had done, quietly, methodically, over the 11 months she had spent handling everything, was introduce a set of amended documents, new signatures, new witnesses, a new distribution, 80% to Sarah, 20% to me, and the 20% routed through an account structure that Patricia described as deliberately complicated had not yet been released. How was this possible? I asked. It shouldn't be, Patricia said. The original documents are clear, but the amended versions were filed with a different attorney who did not have access to the original records. Without someone raising the discrepancy, they proceed. And if someone raises it? A pause. Then you go to court, she said, and you bring proof. I sat in my car in the parking garage for 40 minutes after that call, not crying, thinking. Sarah had done this deliberately, methodically, over 11 months of offering to handle everything while I grieved and trusted and assumed that family was something that held under pressure. She had used my grief as cover, my trust as a tool, my quietness as an assumption that I wouldn't look too closely. She had known me well enough to know exactly how to do it, and she had done it anyway. I called a litigation attorney the next morning. Her name was Margaret Collins. She had a reputation for family estate cases specifically, the kind that involve document fraud and the specific cruelty of people who weaponize grief. She listened to everything without interrupting. When I finished, she said, "Do you have access to the original documents?" "Patricia has them," I said. "Communication records, emails, anything from the 11 months your sister was managing the estate." I thought about this. Sarah had used our family email chain for most of the estate communication. I had not deleted any of it. "Yes," I said. "Bank records? Any indication of when the account structures were established?" "I can get them," I said. "Good," Margaret said, "because here is what I'm seeing. Original documents that are clear and properly executed, amended documents that are inconsistent with your parents' known intentions, and an 11-month window during which one party had sole control of the process." She paused. "This is not a complicated case, Emily. It's a dishonest one. There's a difference." Margaret and I went through everything. Every email from the 11-month period, every document, every communication between Sarah and the secondary attorney whose name appeared on the amended filings. We found 3 things that Margaret described as significant. The first was a discrepancy in the signature dates. The amended documents were dated 6 weeks after our mother's passing, but an email in the family chain, sent by Sarah, referenced estate decisions that had already been made at a point that predated those signatures. "She was planning this before your mother died," Margaret said quietly. I absorbed that, sat with it. Before our mother died. The second was a witness signature on the amended documents, a name I recognized, a friend of Sarah's, someone who had attended Sarah's wedding, someone whose relationship to my sister should have disqualified them from serving as an independent witness. "This alone," Margaret said, "creates significant questions about the validity of the document." The third was a bank record, an account established in Sarah's name alone 14 months before our mother's passing. She built the infrastructure first, then created the documents to direct the funds into it. 14 months before our mother passed, while our mother was still alive, while Sarah was still calling every Sunday and organizing family dinners and being the daughter who maintained joy, while she was planning. I did not contact Sarah during those 3 months. Margaret advised against it. "Anything you say now becomes part of the record," she said. "Let the court be where this conversation happens." I honored that. It was the hardest thing I had done since losing my parents. Because Sarah called. Twice a week, reliably, with the cheerful efficiency of a person who had no idea that everything was about to change. Asking how I was, mentioning family things, performing the role of sister with the same practiced ease that I now understood she had been performing for much longer than I had realized. I answered. I said I was fine. I said I was managing. Fine had become the word I used when I was doing the opposite. The hearing was on a Tuesday morning in March. I wore navy, not for a performance. I am not a performative person, but because my mother had always said that navy was the color of someone who means business without needing to announce it. I carried a folder. Inside the folder was everything: the original will, the email chain, the witness conflict documentation, the bank account establishment records, a statement from Patricia, 32 years of professional history with my parents, willing to testify about their clearly expressed intentions. And one more thing, a handwritten letter from my mother, written to me specifically, not as a legal document, but as a personal one, found in a box of her things that Sarah had apparently overlooked when she was handling everything. In it, my mother wrote about fairness, about her daughters, about her absolute certainty that what she and my father had built should be divided equally between the two people they had loved equally. "I trust you both," she had written, "but I trust you to know what is right." Sarah arrived at the courthouse with her attorney. She saw me in the corridor. For a moment, just a moment, something crossed her face. Not guilt exactly, the specific expression of someone who has been caught in the distance between who they present themselves to be and who they actually are. Then the professional mask came back. She nodded at me, I nodded back, and we walked into the courtroom. Margaret presented everything methodically. The original documents, the discrepancies, the witness conflict, the account records, Patricia's statement, and the letter. The judge, a woman in her 60s who had the specific composure of someone who has heard every version of this story, read the letter twice. Then she looked at Sarah's attorney. "Counsel," she said, "I'd like to hear your explanation for the witness relationship." Sarah's attorney began speaking. I watched Sarah. She was looking at the table, the specific way people look at tables when they have run out of versions. The ruling came 6 weeks later. The amended documents were invalidated. The estate was redistributed according to the original will, 50-50, the way my parents had intended, the way it had always been supposed to be. People ask if Sarah and I have spoken since. Once. She called 3 weeks after the ruling. She did not apologize exactly. She said, "I don't expect you to understand." I said, "I understand completely. That's the problem." And I hung up. I am not waiting for an apology that may never come. I am not building my recovery around a reconciliation that requires her to become someone she has shown me she is not. What I am doing is simpler. I am living in the house my parents built, tending the garden my mother planted, managing the inheritance my father spent 40 years creating, the way they intended, equally, fairly, mine. And every morning when the light comes through the kitchen window, I think about 2 people who loved their daughters equally and trusted that love to hold. It held, just not in the way anyone expected.